So the Supreme Court held in a unanimous decision that full-length human genes are not patentable subject matter under the Patent Act, but that short pieces of human genes called cDNAs, in fact, are patentable subject matter. So if you find a human gene, if you make a discovery, that discovery, the court says, is so fundamental, is so important to innovation, that we're not going to allow any one company to monopolize it. On the other hand, if you engage in manipulation, if you add to it, if you do things with that human gene, then subject to subsequent decisions, that is patentable. So this case was brought by the ACLU and the Public Patent Foundation against Myriad Genetics. Myriad is a genetic diagnostic company that holds the patents at issue in this case, that are patents covering the 2 genes associated with an increased susceptibility to breast cancer. What the court has held is that some of Myriad's patents are invalid, but not all of them. Some claims are directed at the full gene. So they simply say, we claim a patent on the BRCA1 gene. That's not eligible subject matter, because the court says that's simply found in nature, and all that Myriad did was find it. And in so doing, by not adding anything, and by walling off from further study an entire area of human endeavor based on this naturally occurring gene, Myriad stepped beyond the bounds of patentable subject matter. On the other hand, this particular subset of human genes that are naturally made in a laboratory from the natural template called cDNAs, because these are made by humans, these in fact are part of the patentable subject matter.
So is this a victory for Dan Ravitcher, who's a professor here at Cardozo?
It is. It's a terrific victory for Dan in a case that he fought for a long time over a number of years. It's a victory for the patient advocates and for the ACLU who were co-counsel and plaintiffs with him. It's a loss in all likelihood for many genetic diagnostic companies. It's not, I think, however, a tremendous loss for the biotechnology industry as a whole. The genetic diagnostic companies like Myriad, to the extent that they rely on full-length gene patents, are likely to be negatively impacted. But biotech companies that don't rely on full-length gene patents, right, that rely on patents on genetic material that's been manipulated or recombined or created by humans in the laboratory in some way or another, likely won't feel a significant impact.
The purpose of patents seems to be to help innovation, companies be innovative. Does this succeed at that, or does it smother innovation?
Yeah, the funny thing about patent cases is you get briefs on both sides, each of which scream at one another that a ruling their way or the other way is going to bring innovation to a halt. And that's just not right. What the Supreme Court has consistently tried to do in its patent jurisprudence, particularly over the last 10 years, is to strike a balance between the needs of the biotech industry and others for incentives to engage in innovation, and the needs of the scientific community and researchers more broadly to freely use products of nature and to freely use the basic tools of scientific understanding without having to pay a license fee for them to a patent holder. I think on balance this ruling helps innovation because it frees up for scientific study the products of nature that we find in our chromosomes. And it allows scientists to continue their research uninhibited by the assertions of exclusive rights by patent holders.